I want you to picture exactly what happened in the moments before this became a news story. It is late January 2026. There is a meeting inside the White House. Seated around the table are Vice President J.D. Vance, Stephen Miller, White House Chief of Staff Susie Wiles, and a lawyer named Will Scharf. Miller is making an argument. He says the limits of a particular constitutional law have never really been tested. And then Scharf, the man who hands the president his executive orders to sign, cuts him off. He says directly, in front of the Vice President of the United States, "That's not true, Stephen. It's very prescriptive." The meeting ended without a decision. But what that meeting was about is the reason you are watching this broadcast tonight. Here is what we know, and here is how we got here. On June 15th, 2026, the New York Times published a report by correspondents Maggie Haberman and Jonathan Swan, drawn from their forthcoming book, Regime Change, Inside the Imperial Presidency of Donald Trump. At the center of the report, two confidential memos written by White House Staff Secretary Will Scharf and addressed to Chief of Staff Susie Wiles, the first dated April 29th, 2025. Those memos and the internal debates surrounding them reveal that senior officials in the Trump White House seriously debated suspending habeas corpus, one of the most fundamental constitutional rights in American law, as a tool to accelerate deportations. Now let me walk you through what this actually looked like, because the sequence matters. Spring 2025. Stephen Miller, the Deputy Chief of Staff for Policy and the architect of this administration's immigration agenda, begins pushing a proposal. The proposal: suspend the constitutional right of detained migrants to challenge their imprisonment in court. The legal term for that right is habeas corpus. Remove it, and the government can detain and deport without a judge ever having to say a word. Miller ordered Justice Department lawyers to study the legal precedents. He was focused on President Abraham Lincoln's use of the power during the Civil War, April 29, 2025. Scharf sends his first confidential memo to Wiles. It runs in careful, lawyerly detail through the entire history of habeas corpus. He writes, "The writ of habeas corpus is a legal mechanism to challenge unjust confinement, detention, or punishment. It prevents, in effect, governmental actors from detaining, imprisoning, or executing individuals arbitrarily." That sentence is from a White House memo, written by a White House lawyer, addressed to the White House Chief of Staff. It is describing a constitutional right that a senior official in the same building wanted to eliminate. Scharf continues. He writes that the Constitution permits suspension of habeas corpus only in cases of rebellion or invasion, and that courts have almost uniformly held that only Congress possesses the authority to do it. He notes habeas corpus has been formally suspended 4 times in the history of the United States. All 4 times, the country was at war or facing armed rebellion. He writes that even Abraham Lincoln, the only president to do it without congressional approval, later sought and received that approval after a court ruled him in violation of the law. Then Scharf writes a line that belongs on the front page of every newspaper in this country. He writes, "The current Supreme Court, however, is likely more amenable to revisiting these questions than any Supreme Court in living memory." The Supreme Court has 6 conservative justices. 3 of them were nominated by Donald Trump. One day after Scharf delivered his memo to Wiles, Trump raised the subject publicly at a cabinet meeting in the context of the case of Kilmar Abrego Garcia, a father from Maryland who had been wrongfully deported to El Salvador's notorious terrorism confinement center. Trump told officials at that meeting, "There's one way that's been used by 3 very highly respected presidents, but we hope we don't have to go that route." Shortly after, Miller told reporters the Constitution was clear that habeas corpus could be suspended in a time of invasion and that it's an option we are actively looking at. The proposal did not move forward in the spring, but it did not die. October 2025. Scharf writes a second memo. This one addresses the Insurrection Act, a separate proposal advanced by Miller. He writes that the Insurrection Act represents a break-the-glass exception to the traditional general prohibition on the use of the military in the domestic setting. January 2026. Federal agents in Minnesota, during immigration enforcement operations, shoot and kill 2 American citizens. Their names are Alex Preddy and Renee Good. Preddy worked nights as an intensive care nurse. Good raised 3 children and wrote poetry. They were killed while protesting. Following those killings, J.D. Vance walks into a senior staff meeting and demands the Insurrection Act be invoked immediately. Miller supports the push. The message it would send, Vance argues, would make sure no one tried to disrupt enforcement operations again. Scharf pushes back. Blair pushes back. Communications Director Stephen Cheung raises the public relations consequences. Nobody can answer the direct question of what, precisely, the Insurrection Act would achieve that existing legal authorities could not. The meeting ends without a decision. The act is not invoked. But that moment is documented. It is in the memos, and now it is in front of you. Now let me tell you what this actually means for real people. Habeas corpus is not an abstract concept. It is the right that says the government must stand before a judge and explain, in specific legal terms, why a specific person is sitting in a specific cell. Remove that right, and the government does not have to explain anything. It detains, it deports, no hearing, no appeal, no judge. The person simply disappears into the system or disappears from the country. The administration has already moved aggressively through other legal channels toward that outcome. A federal court ruled this year that the administration could fast-track deportations for millions without formal hearings. The Supreme Court has allowed deportations to countries where detainees have no ties. The court this week ended legal protections for 350,000 Haitians and 6,000 Syrians. Each of those moves is documented. Each of those moves delivers a piece of what suspension of habeas corpus would have delivered all at once. The plan in the memos was the most direct version of a strategy the administration has been pursuing through a dozen different doors. At the political level, the White House response on June 15th, delivered by spokeswoman Abigail Jackson, was this. Members of the administration often have conversations about many different lawful options to implement the president's agenda, with the president always being the ultimate decider. Note what that statement does not say. It does not say the proposal was rejected. It does not say habeas corpus will not be revisited. It says the president is the ultimate decider. That is not a denial. That is a description of a process that has not concluded. At the structural level, this story is about something larger than any single memo. Step back for a moment, because the bigger picture here matters. The reporting reveals that two of the most powerful people in the executive branch, the vice president and the deputy chief of staff for policy, advocated for suspending a constitutional right without congressional authorization, and that they were stopped not by political opposition, not by courts, but by a lawyer in the same building who understood the legal history better and who was willing, in a room with the vice president, to say, "That's not true." What the pattern here appears to show is that the guardrails in this administration are not institutional. They are personal. They depend on individual lawyers in individual rooms being willing to push back at the right moment. Aaron Reichlin-Melnick, senior fellow at the American Immigration Council, said directly that Miller would happily shred the Constitution into little pieces if he could. Steve Vladek, a constitutional law professor at Georgetown, called Miller's public statements about habeas corpus the most remarkable and remarkably scary comments about federal courts that I think we've ever heard from a senior White House official. Mark Elias, an attorney for the Democratic Party, was precise. Congress has the authority to suspend habeas corpus, not Stephen Miller, not the president. That is analysis from named experts based on documented facts. What is confirmed is that the proposal reached the level of the vice president, generated at least 2 confidential legal memos from the White House's own staff secretary, and that the idea, in the words of the raw story summary of the NYT reporting, has not been set aside and remains in consideration. What did the people responsible for this proposal say? Miller said habeas corpus suspension was an option we are actively looking at. That was his public statement while Scharf's memo was sitting in Wiles's inbox. He has not publicly walked it back. As of this broadcast, Stephen Miller has offered no substantive response to the specific content of the Scharf memos. That silence tells us something. J.D. Vance, whose January push to invoke the Insurrection Act is now documented, has offered no public accounting of the meeting in Wiles's office described in the New York Times reporting. That silence tells us something, too. The White House's formal statement says the president is the ultimate decider. Here is the question that statement raises and does not answer. What happens the next time the question is asked if the lawyer willing to say, "That's not true," is no longer in the room? Here is what they said then, and here is what they are saying now. In April 2025, Scharf wrote privately to Wiles that suspending habeas corpus without congressional authorization would almost certainly collapse in court. In May 2025, Miller told reporters publicly that it was an option we are actively looking at. Those two statements were produced inside the same White House, within weeks of each other. The viewer can do the math. We have been here before. This is not the first time an American administration has debated whether emergency powers could be stretched to cover the systematic detention and removal of a group of people it had decided were a threat. The internment of Japanese Americans during World War II was legally blessed at the time. It was called a national security necessity. It was driven by fear, by executive action, and by courts that deferred. Congress eventually apologized in 1988 with the Civil Liberties Act and paid reparations to survivors. The legal argument that justified internment, that the executive branch could act against a class of people in a time of national emergency without the usual constitutional constraints, is structurally similar to the argument in the memos that Scharf rejected. That history does not tell us what will happen now. Reporting suggests it does tell us what becomes possible when the argument succeeds. What we are really deciding tonight is not a policy question. It is a question about who we are willing to leave behind. The person in the detention facility who cannot get before a judge. The father deported to El Salvador before a court could hear his name. The American citizen killed in Minneapolis, whose death became an argument for military deployment. These are not abstractions. They have names. And the memos are real. Tonight's comment question. Drop A if you believe habeas corpus should never be suspended for immigration enforcement, regardless of administration. Drop B if you believe the president should have the authority to suspend habeas corpus during a declared national emergency with congressional oversight. Drop C if you believe this decision should rest with Congress alone and that any unilateral executive action is a constitutional violation. These are not political positions. They are the exact questions the memos asked. You deserve to weigh in.